This is Twit.
The future of television is being decided by the Supreme Court starting today. Aereo defends itself in a lawsuit by ABC, CBS, NBC, and other major broadcasters. Aereo says they're simply renting dime-sized TV antennas. Broadcasters say they're stealing TV shows and selling them without paying the content creators or owners. If Aereo wins the case, mainstream broadcasters could move to cable, and a new live streaming TV business model would be legitimized. If Aereo loses the case, they'll go out of business immediately. Jordan Crook is a writer and reporter for TechCrunch and posted an exclusive interview this morning with Aereo CEO Chet Kanogia. Welcome to you.
Hi, thanks for having me.
Now, the existence of Chet Kanogia's company will be determined by the outcome of this case. How confident is he that Aereo will prevail?
Well, Chet is very hesitant to answer that question. And to be quite clear, Aereo may not go out of business even if they lose this case. It all depends on kind of the scope of the decision that's made by the Supreme Court justices. They may decide the relief that was being sought for by ABC and these other companies was maybe that, users couldn't record the television shows while they were on the air or while they were live. But could watch them after the fact. So that's a potential outcome as well. In terms of his confidence, I think he believes in his merits. The company itself was built to withstand and to be within the law. And so I think that he is very confident going in, but you never know what could happen. I mean, these are people trying to understand something that's very complicated and nuanced and is up for, debate, I guess, in a lot of ways.
Now, this is a rare kind of case because it's really unclear what the outcome will be, and it really could go either way. Essentially, to oversimplify the contest here, Aereo says that they rent little antennas, and they also rent specific space on servers in their data centers to people who want to just get regular broadcast TV. In other words, it's like an antenna on your roof, except it's not on your roof. It's in with their data center. And then when you download and sort of TiVo or record a show or something like that, they keep it in the cloud for you, but they don't duplicate it. In other words, if 100 people sort of record the same show, they don't just make one copy. They make 100 copies. Each person has their own specific space on their hard drives. And so they're basically saying that this is a private viewing, that they're just renting this equipment. And then the broadcasters are saying, no, this is presented as an alternative to cable. And so they need to pay us if they're going to be using this content, and that this is, in fact, a public performance, as they call it, and therefore this is an illegal use of their content. Now, you asked Chet Kanogia about what I think is an unexpected factor in this case, which is that the Assistant Attorney General and Copyright Office will be speaking today on behalf of the broadcasters and against Aereo during oral arguments. Does he find it unfair that the U.S. government is actually taking sides in this case?
I don't know. How unfair is it that major companies like Google and Facebook are taking Aereo's side? I think that both entities are probably equally as powerful. And so when you look at it, yes, it is slightly unexpected. And I personally think that it's a totally ridiculous move by the United States government. I think it shows a lack of maybe understanding or a forethought looking towards the future. But I don't think that he's necessarily worried about it. And I think that he trusts, the Supreme Court was put in place to not necessarily have to answer to the government in that way. So I think that he is very confident in the wisdom of the judges. And I don't think that he's necessarily distracted by that appearance.
Yeah, I mean, I understand the Googles of the world taking sides in this because they have a financial interest, and it's their job and their responsibility to their shareholders to do whatever's in the interest of themselves and their customers. The government is supposed to represent the people and balance the interests of industry versus the rights and so on of the people. And there's also the historic question of who owns the airwaves and what you can do with what's broadcast over the airwaves. And so that's what makes it surprising to me that the government is getting involved in this case. They really, it seems to me that it would be much more reasonable for them to just butt out and just let the Supreme Court handle it without them taking sides one way or the other. Now, Chet Kanogia focuses on the transmit clause to make the point that the outcome of this case could affect all cloud storage providers such as Google and Dropbox. What is his point there? It's an interesting take on this case, I think.
Yeah, it is, and it's very complicated, actually. So it all kind of relates back to Aereo's initial argument. And so what they're saying is that Aereo is a combination of two services. You're essentially renting an antenna instead of buying one at the hardware store or the electronics store and putting it on your TV. So you're renting that antenna, and then the second part of the service is this cloud DVR, which is very, very similar to what you get in Dropbox or Google Drive. It's storing stuff on a server, and you access it from whatever device you'd like. In the case of the transmit clause, the broadcasters are arguing that every time that a private transmission is made, so that means that if I buy a Lady Gaga song on iTunes and I put it in Google Drive, every time that that happens, because that's one copy that we got from iTunes, and then it became my copy. If I switch it over to Google Drive, every time that someone does that, those should be counted as aggregate transmissions, which would make that public. That is essentially what they're arguing for Aereo. And then the implication of that is that, like I said, anytime that someone loads something up in Google Drive, it should be counted as the aggregate private transmissions. And that is how you decide whether or not it's public or private, if 10,000 people are doing it or if one person is doing it. And Chet's argument is essentially that within the transmit clause in the Copyright Act, there is no indication whatsoever that these transmissions should be aggregated or re-aggregated. When it essentially, once it goes private, once I own it, I have the right to do whatever I'd like with it, and it can't go from private to public. That's not really how it works. And so I think that that's kind of the argument that he's making. And a lot of the broadcasters are coming back and saying, well, Google Drive and Dropbox, they don't actually provide the content in the first place. People aren't getting content from Dropbox and then transmitting it up and down, right? And the way that Chet looks at that is he says, well, we're not actually providing the content either. Our system sits entirely dead. It's not tuned to any frequency. It's not recording anything until the user who has rented that antenna tunes to a certain channel, captures that content, and chooses to watch it at the time and place of their choosing. And so it kind of all feeds back into his original argument, I guess.
Yeah, and Peter Rojas, this to me is the most fascinating thing about this case. From the point of view of Aereo, they're simply making their equipment available and allowing users to use their services to download TV shows from the airwaves, so it's not originating with Aereo, and then store it on their equipment. And so from their perspective, they're not providing content. From the point of view of the users are using Aereo as an alternative to companies that do provide content. So the experience of using Aereo is very similar to using having a cable subscription service or something like that. So like, this is really the case. What matters, the user experience or Aereo's facts about where the content is coming from?
Well, I mean, this is why the law that we have governing this stuff doesn't really make as much sense in the internet age. And I think that even the Betamax ruling, which clearly makes it legal for people to record television broadcasts. I think there's the question is whether that is something that should be considered. I mean, whether it should be considered a purely sort of private act, or whether it's something that could be done, that could be contracted out to a business outside the home. I actually think that the idea that that Aereo is creating a public transmission, I don't necessarily buy that. But I think that there's some haziness around the idea of if you're taking, that it's clear that you can record, public television broadcasts in your privacy of your home and use them, in the privacy of your home. I think that, to me, that the question is it legal to contract that to someone outside of the home? And my sense is that the law probably does allow that because the law was not written with this scenario in mind. But I think that we're sort of showing that the shortcomings of these situations and how it's not as easy to delineate where, an activity stops being public and becomes private, or vice versa.
Well, and again, Aereo would not consider them to have the contractor for the recording. Like, that's not what they consider their business to be. They're not recording the content.
Sure.
The user is recording the content. I mean, the granular details of it are where it becomes hazy, because it's the combination of these two businesses, of the antenna and then the recording and cloud storage. So it's like that's where things get really mucky, I think.
Yeah. I mean, clearly you are allowed to, like, if I hired you to come into my home and set up a server and an antenna and to do all those services, and I even paid you to do them for me and even paid you per month to rent that equipment, that would be allowed. I think it's this idea of once you take it outside of the home, does it sort of, you lose the aura of it being a personal private activity and becoming a public activity? Not even in terms of transaction, but in terms of for personal use.
Right. Okay, I can see where you're coming on. Because, there are two precedents that are at play here. It's not just Sony Betamax, because that's the right to record public broadcasts. Yeah. And then there's also Cablevision, which was from a few years ago, which is much more recent. And Cablevision was essentially arguing that if I have a DVR service and the recording, the actual content itself that I'm recording is stored in the cloud, people were all upset about that. That seemed like it should be wrong. And Cablevision won the case. And they said, as long as the user is in charge of the recording itself and in charge of the copy and decides when and how they want to watch it, and it doesn't matter if it's stored in their living room or if it's stored in a server, that's owned by Cablevision. And so those two precedents are kind of what the broadcasters are looking, or maybe not the first one, but Cablevision is something they're definitely looking to overturn. And that is where all of the Dropbox, Google Drive hysteria comes into play.